Duncan says, if you want to know about business, health, and places to go, welcome to the show. Yeah, welcome to the show. If you know that you want to grow your business, your practice, and portfolio, welcome to the show. Yeah, welcome to the show.
Hello, and welcome to I'm Simply Saying, the healthcast where the spine meets strategy, alternative healthcare takes center stage, and we discuss how to build thriving medical clinics. I'm your host, Dr. Mary Frances Duncan, founder and CEO of Simply Southern Chiropractic Center in South Carolina. I'm a chiropractor by trade in an entrepreneur's body. I'm excited to guide you through this journey at the crossroads of chiropractic care, integrative medicine, and the art of successful clinic management. Lastly, if you take anything away from this episode today, please leave this podcast a 5-star review. Reviews allow us to hear from our listeners and what interests you. So, without further ado, let's get into the backbone of it all. Welcome to I'm Simply Saying.
Hello, and welcome to I'm Simply Saying. Today's episode is called Car Wrecks, Necks, and Checks. And this is a very clever way to talk about personal injury basics for the chiropractor. We have two parts of this podcast. So this is part one of all of the nitty gritty and getting into this gray area of personal injury cases and chiropractic care, specifically for practice owners. So today, for this podcast, we have a special guest with us, Dr. Duncan's husband, Will Maxey, who is a local personal injury lawyer in Greenville, South Carolina. And we will be really breaking down with him and Dr. Duncan the importance of all of the topics when it comes to personal injury cases and chiropractic care. Before we really hop into it and we introduce Will, I just want to say first, if you do take anything away from this today, Dr. Duncan's website, drmaryfrancesduncan.com, offers so much additional information with online courses and coaching one-on-one with Dr. Duncan that you can do and really break down this even more with her one-on-one, which is just really spectacular. Additionally, as well, if you do take anything away from this podcast today, please leave us a 5-star review. These reviews help us understand what you want to listen to and why you listen to I'm Simply Saying. And so we really want to make sure we cater this exactly to what you want to hear. So without further ado, we'd love to introduce Will and kind of get his backstory. So let's get started.
All right. Hey, everybody. I'm Dr. Duncan, and thank you for joining us today. With this very unique episode, we have our first special guest. So this is my husband, Will Maxey.
Hey, well, I'm glad to be here. Thanks for having me on the podcast. I'm looking forward to talking about personal injury cases and how they interact with the world of chiropractic.
All right. Well, let's sort of get started here. So tell us a little bit about yourself and then, tell us why you decided to become not only a lawyer, but a personal injury lawyer.
Sure. Well, again, I'm Will Maxey. I'm an attorney in Greenville. Not to go too far back, but I grew up near Myrtle Beach, Conway. I went to Clemson for undergrad. I went to the University of South Carolina for law school, but I've always wanted to be a lawyer. I have always wanted to be a lawyer because it's a profession where you get the opportunity to take on someone else's cause as your own. You get to be someone else's advocate. And you get to help somebody in the moment that they need somebody to help them the most. And personal injury cases are the most, to me, about the most impactful opportunity to do that. You have the opportunity, and I see it as I've always identified with, the little guy, the underdog, and being a plaintiff's attorney representing injured people is the ultimate way to do that. Because you have a chance to tell the story of somebody who has been injured through no fault of their own, usually through someone else's absolute carelessness or recklessness, and you get to explain to a jury how that impacted their life, how that impacted their family, how that cost them their livelihood in some cases. In some cases, how that's cost them, thousands and thousands and thousands of dollars in medical bills. And on the other side, you have a multi-billion-dollar corporation that does not care at all about the human cost of their insured's actions, and their job is not to stand up for somebody, but their job is to maximize their shareholders' return and make sure that they pay as little money as possible. And that is the kind of fight that I will get up for every morning and go to work for and fight as hard as I can for. There's a lot of jobs out there that is hard to get fired up about, but as you can tell, it's something that I feel very, very passionately about. And I actually have my own personal injury law firm with my partner, Elizabeth McFarland. We opened Maxey McFarland Law Firm last October, so it's still pretty new. But we're located in downtown Greenville, and we are carrying on that fight for our clients every day.
Thank you so much for being here with us today. We are all very excited to get your perspective, and I would love to ask you some questions that I know that a lot of chiropractors that are listening have. First of all, will you tell us what personal injury is and what is a personal injury case? Say we're talking to chiropractors that maybe are in chiropractic school or just started in practice. They've never worked with car wreck cases. Just tell us what is personal injury?
Sure. A personal injury is really almost as basic as it sounds. It's a person who suffers an injury due to someone else's negligence or recklessness. The most common application of that is in a car accident case. Situations where somebody might be rear-ended by somebody who's not paying attention, somebody who runs a red light and runs into the side of somebody, and that causes injury to them. Any number of injuries can be caused by a car accident. Obviously, motor vehicles are very heavy and moving at high rates of speed, and they're dangerous whenever people are not adequately controlling their vehicles or paying attention to the road. And chiropractors help address some of those injuries and provide a valuable service for personal injury victims. A personal injury case is a claim made by somebody that's injured in an accident that's caused by somebody else. That's the most important part. From the legal aspect is, an attorney brings a case for negligence, gross negligence, any other causes of action, which again is a legal term of art, just meaning a type of lawsuit, essentially. And for that to exist, there has to be some evidence that the other party, was at fault for the accident. That's what most people call it. Commonly, we use terms like liability and negligence all the time in my field, but basically that's what that means is, was the other driver at fault? So for there to be a personal injury case, you got to have somebody that was injured, and they have to be injured by somebody else who was at fault for causing the injury.
All right. Well, I have a question. So are there personal injury cases that are not car wrecks, just so that we can all be on the same page?
Certainly, yeah. People suffer personal injuries in other types of accidents. Another common type would be a slip and fall or a trip and fall at a business. The fault analysis is a little different there, and that varies widely from state to state. The law on what's called premises liability, which is the law around business owners and other entities that allow the public to come onto their premises. They have to take care of their property to make sure that it's safe for other people. They have differing legal duties depending on the state. Here in South Carolina, if you're a business invitee, in other words, somebody who's on a business's premises, a paying customer or potential paying customer, or somebody who has some business purpose there, you have to make sure that your floors are clean. You don't have random objects lying around on the floor. You got to take reasonable care to make sure that the business, the floor and area occupied by the customers is made safe for them, and reasonably so.
Thank you. Well, I think that helps clear up some questions that listeners may have. So there is value in taking personal injury patients, and that is what we are going to talk about today, and sort of demystify what to do in a personal injury case and how to work with an attorney. So one of the things as a chiropractor and a business owner that I have always thought about is, should we be taking personal injury patients into our clinic? Is this worth our time to treat? before we get started into how to treat and, what information is needed from an attorney or from an insurance company, I think it's great to have a variety of patients. So we take health insurance in our clinic. That's nice, and people can use the health insurance that they pay for through their work. We have cash paying patients. We are not an all cash clinic. We want people to be able to use their insurance if they have it. And then personal injury is a small part of our practice. Less than 5% of our practice is personal injury, but personal injury, it's one of those things that in practice, when we treat the patient, we're going to talk about this, but you're not going to get paid on these cases sometimes for years. And so they pay decent, they pay well. These cases require a lot of paperwork, and it requires a lot of detail. So it requires a lot of work, and you can do well and you can profit from these cases, but just know that this is like sort of a long-term game. You're not going to get paid immediately with these sort of cases. So I suggest that to have a thriving wellness practice, it does not need to be personal injury based. There is a time and a place for these patients to be in your practice, but that's having a personal injury practice, in my opinion, is not a sustainable model. With personal injury patients that have been in a wreck, typically they're going to come in and they are going to be treated on a lien. So they're not going to pay you in the clinic. And once they hit maximum medical improvement, MMI, which we will also define and talk about, and we recommend maintenance care, and the patients have to pay at that time, and typically they're not going to stay on as patients. So if you have a personal injury only clinic, you're constantly trying to find new patients. And sometimes, we want patients that are going to stay with us long term, and that's not typically the case with personal injury clients. The good thing about taking personal injury cases is sometimes when someone's in a car wreck, that's their introduction to chiropractic care. So we want, our state and our country, we want patients to be under maintenance chiropractic care, for throughout their lives. It helps so much with mobility and with our nervous systems and our immune systems. And so this is a great introduction for someone to chiropractic care that may have never gone to a chiropractor before. So Will, can we just start with some car accident basics? So let's just start with, what are things that a chiropractor needs to check for when a personal injury patient comes in the door, or a patient that's been in a car wreck?
Sure. Well, the first thing, especially in states like South Carolina, is you need to establish whether or not your patient is likely to be found at fault for the accident or not. Because you're going to need to prove, or not you, but your client and your client's attorney need to prove. Sorry, your patient's attorney are going to need to prove that it wasn't the patient's fault in order for the patient to be able to recover any funds from the at-fault driver's car insurance company. Obviously, that's something that is really sort of more a lawyer's job in some ways, is assessing liability and evaluating liability. But an easy way you can do that is in South Carolina, and other states have similar forms too. The highway patrol or the investigating agency that shows up to the scene of the crash generates what's called an FR-10. And the FR-10 is a form that shows who the officer believes, based on his investigation, is at fault for the collision. And if it's not your patient, that's the first thing you want to see, is that your patient was not found by the officer to be at fault. Things like rear end collisions, people running stop signs and T-boning people, clear liability situations. What you would want to avoid as a chiropractor is getting involved with cases where it's a he said, she said type situation, and it's not really clear whose fault it is, or most obviously a situation where your patient rear-ended somebody else. You wouldn't want to take on a case where your patient was clearly at fault. And the reason that's important is for you to be able to collect anything from a bodily injury liability policy. In other words, car insurance, as we think about it. Your patient is going to need to be able to show that the accident was the other person's fault.
What about can you explain the difference between a no fault and an at fault state? And say you were in an at fault, or excuse me, a no fault state, and our patient hit somebody else.
Sure. Now, I've never practiced in a no fault state, as some people call it, but what I can say is um, it's not as important from the chiropractor standpoint, because the chiropractor is trying to provide their patient with treatment to help them get better, to help them recover from their injuries. And in non fault or no fault states, you have things like PIP or med pay, which are first party insurance coverages, which means the person who has the coverage can use it. So if you're driving down the street and you get injured, regardless of if it's your fault, you can make a claim on your PIP, in other words, personal injury protection coverage, or med pay, medical payments coverage, where you could submit those bills to the carrier regardless of whether it's your fault. And the provider that rendered those services would be paid for those. And in chiropractors' cases, the chiropractor or his or her office could submit those bills to the PIP or MedPay carrier for payment.
So we are here in South Carolina. So tell us, what is our state?
South Carolina is a state where it's a fault state, where typically you have to show fault to recover. Now, people in South Carolina can buy PIP coverage or MedPay coverage. That does exist. However, unlike no fault states, it's not mandatory. In South Carolina, all you have to buy to be street legal is $25,000 of bodily injury liability coverage, $50,000 per accident, and $25,000 in property damage. MedPay and PIP are optional coverages. You do not have to purchase them. And the vast majority of drivers in South Carolina do not.
So for chiropractors, does it matter to us if a patient has PIP or MedPay in South Carolina when we're an at-fault state?
Well, if they do, I mean, you could submit those bills to the PIP or MedPay carrier for payment. But generally speaking, you just to be absolutely safe and make sure that you are going to be compensated for your services, you would want to make sure that your client was not the at-fault party.
And how would we know that? So say, the patient tells us, oh, it wasn't my fault. I was rear-ended from behind. But is there a way that we can go and see if they're telling the truth?
Yeah, and that's what I was mentioning earlier. You could have the patient provide you a copy of the FR-10, and that way you can see very clearly on the FR-10 who the officer believes caused the accident. In South Carolina, it says contributed to collision, and then under that, it'll say yes or no, and then the officer will circle the one that applies. So if your client's name has contributed to collision, no, circled on it, then it's not your client's fault in the officer's judgment. Or if your client did cause the accident, contributed to collision, yes. In that situation, you would not want to be involved in that personal injury case from a treating provider standpoint or otherwise.
So, Will, is this something when the patient comes into our clinic, do we want to ask the patient for this FR-10? Did they have access to it, or where do we find this? Where do we get this?
Yeah, your patient has to provide that to you. The FR-10 is, again, provided at the scene of the collision by the highway patrolman or the officer that responds to the collision, who's the investigating officer. They print out those on the scene and they provide them to both drivers, or sometimes there's more than two drivers, to all the drivers at the scene.
Well, when I first started in practice, we would get these incident reports and they would have all the information that we needed on it. But recently, in the last several years, sometimes when our patients bring in these FR-10s, a lot of it is blacked out and we don't have all the information. So why is some of the information blocked out? And is there a way we can get an FR-10 that doesn't have information blocked out?
Well, I'll say this, from the chiropractor standpoint, the information that's blacked out is not necessarily useful to you. The information that's been blacked out in recent years, and the reason that I've heard cited by the Department of Public Safety is for privacy concerns, is both drivers' birth date, and sometimes some demographic information about them. That's usually the only thing that I've seen redacted from those. The part that you really need is the insurance company's name and the policy number of the insurance policy, and those will not be redacted. That's one of the primary functions of the FR-10.
Okay. So tell me, are there other names? What are all the names for an FR-10?
Well, so that's funny that you should ask that because my clients sometimes get these things mixed up too. The FR-10 is the form that they print out and hand to you at the scene of the collision. Some people call it the incident report, the police report. It's really not either one of those. The FR-10 really just lists the name of the driver, their home address, and their insurance company and policy number. And then, of course, the portion that I was discussing earlier that says whose fault it was. The full police report is something called a TR310, and it includes some more information. It'll include a lot of that same information again, including the contributed to collision portion. It'll also have a diagram that the officer makes that shows the relative positions of the cars, what direction they were going, a very rudimentary sort of depiction of the roadway. And then it'll also have a narrative explaining how the accident happened, according to the officer after taking statements from all the drivers and witnesses.
Okay. Well, thank you for that information. I think that clears some things up. In my experience with the attorneys that we typically work with, if we need access to these FR-10s without information blocked out, they usually seem to get it within about a month's time. And so we email them, and usually they'll email us that full report. If you do want to verify and check names, birth dates, things like that. And like Will said, when we're documenting in our office, it is important to know the insurance company of the at-fault party, because that is who we put on our billing records that we print out or send electronically. All right, so let's get started here. So I think we've gone over some basics about what is personal injury. So in your opinion, should patients work with an attorney? So again, we are pretty much talking about this from the perspective of South Carolina, which is an at-fault state. So why does a patient need to use an attorney? And if so, why?
Yes. That's the shortest and simplest way to put it. But the reason for that is insurance companies just really fight these claims harder than ever before, especially the types of injuries treated by chiropractors, which in the insurance industry and civil litigation generally are often described as soft tissue injuries. Cases where you have a muscular sprain or strain, pulled muscle, things that do not show up on any kind of imaging. Things you're not going to see on an x-ray or CT or an MRI. And the reason that's important is it comes down to the credibility of the injured person, right? These are injuries that the insurance industry and defense lawyers like to poo-poo or act like they're not real, they're being exaggerated. These are the ones that they fight the hardest. And so it's important to have an attorney to be able to prove your case to the insurance company, and if it comes down to it, to a jury, if you have to try the case, to be able to prove your case and be able to get the insurance company to pay what they should pay, not just for your medical bills, but for having to go through this experience, having to suffer pain for an extended period of time that you didn't have before. The loss of quality of life that you have, even in what they call a soft tissue case. I mean, waking up every day with pain in your neck that's worse by the end of the day, and it just doesn't go away for weeks and weeks and weeks. It's important to have an attorney to help tell that story, either to an insurance adjuster before you file a lawsuit, or to a jury if that becomes necessary.
So, Will, what would you say? I know you hear this. I hear it too. We'll have patients say, I'm not the type to sue. I'm not the type to get an attorney. What would you say to that?
Well, what I would say to that is that that's not very wise, to say the least. Whenever people say that, it's because they like to think of these things as something that doesn't happen to them. They like to, well, that's what these other people have going on, not me. But when it happens to you and it's real to you, to the kind of folks that say that, you need to get somebody on your side to tell that story, because the insurance company, especially the other driver's insurance company, is not looking out for you.
Mhm.
They are finding ways to save money. They are finding ways to say that you're exaggerating, and at worst, to say that you're lying. And they will do that. That is what they will do. They will stop at nothing to try to save money, to try to avoid doing what they're supposed to do, which is to compensate people for the injuries that their insurance caused. And they don't want to do that. And unless you have somebody with the skills, the aptitude, and the ability to force them to do that, well, it's just not going to happen for you. They're going to start fighting you on things like, well, that chiropractic treatment you got, that wasn't necessary. You didn't need that. And unless you have an attorney who can show, no, this was necessary, and has the ability to present that to a jury in a way that will get in the courtroom, that a judge will allow it into evidence. And they know that you're not going to do that by yourself. They know that you don't know the rules of evidence. They know that you don't know the rules of civil procedure. They know that you're, no offense, folks, listen to this. If you're not a lawyer, you're completely ill-equipped to prove that case. You have no idea how to do that. So until you get somebody on your side who does know how to do that, they're not going to take you seriously, and they're not going to take your injury seriously.
I definitely agree with that. And so from my experience as a practice owner, when I first started in practice, I didn't know much about personal injury. And so I would take a patient and I would process them like I normally would. And I would bill their car insurance, or I would bill the car insurance of the at-fault party, just like we would bill health insurance. And the car insurance was very slow to respond, and we were pretty much finished with treatment. The patient had met MMI, or maximum medical improvement, by the time that they responded to me, and we had done this treatment. And I mean, we're chiropractors. I mean, our bills aren't like these massive hospital bills. They're pretty small compared to, what some other doctors' visits cost. But I would get denied by these insurance companies. And I did that for 2 personal injury cases. And then after that, after getting paid for half of the treatment, and the insurance company would say that the treatment wasn't necessary. And after that happened twice, I just decided the patients in our clinic, they can pay out of pocket. So they can pay us and we will supply them with the records, and they can turn those records in to the at-fault insurance company. Or, this is our preferred method, is they can work with an attorney and we can treat them on a lien where they don't pay while they're in active treatment after their, usually it's a car accident. And so over the years, we found attorneys like locally that we really enjoy working with. We've got 2 or 3 that I trust, and I know that they have our best interest in mind as well as our patient. And I think there's value in creating that relationship with a local attorney. And so Will, this is speaking directly to chiropractors. How would a chiropractor, how would they know if an attorney was trustworthy? And because I've had this happen to me, and this sometimes happens with out-of-state attorneys. I feel like we have more issues with them where we talk about lawyers screwing over chiropractors. It has happened. It doesn't usually happen locally because I have a personal relationship with these people. But what are some things that chiropractors should look out for? Because some of this is, unfortunately, it is real.
Yeah, unfortunately, like any other profession, there are unscrupulous lawyers out there. One thing you can do if you're introduced to somebody that you don't know or that you have no prior relationship with, I mean, you can look up on the South Carolina Supreme Court's website, whether or not that lawyer's ever had any prior disciplinary history with the bar, whether they've been punished by the Supreme Court, or worse, disbarred at some point for any sort of misconduct as an attorney. Another thing is really, like you said, Dr. Duncan, is just the personal relationships. Like, you need to know who you're dealing with. You need to ask around your community, your city or your town. Like, have you heard of so-and-so? Do you know him? Do you know her? Is this somebody that you trust? And really, it's a lot of that is just being able to gauge whether or not you trust somebody, whether or not, what they say sounds too good to be true. But I think the most important thing is making sure that your values are aligned. Making sure that what this is about, from my standpoint as an attorney, is making sure that my clients are fairly compensated for what they go through. And as a chiropractor, for y'all, your goal is to make sure that your patient receives the care that they need. And it's that simple. If anybody starts, like a lawyer starts talking to you about, oh, you can make so much money on these, you can do this, that, and the other, like that. Obviously, money is involved in this. All a personal injury lawyer can do for their clients is obtain money, whether that's a judgment or a settlement. But that's not the primary driving factor there. The primary driving factor is making sure that the patient receives the treatment that they need and that the client receives the compensation that is fair and that is just. Nothing more, nothing less. If you talk to somebody that sounds like they have other motivations primarily, or you just don't get a good vibe from them when you meet them, then your gut's probably right about that, and you should avoid doing any kind of business with that person.
I think that's great advice. And in general, I want to say I feel like lawyers, especially personal injury attorneys, are our friends. They do value what we do as chiropractors, and they can be a great resource. If you get a referral of a patient from a personal injury attorney, typically in my experience, lawyers are not going to send you cases that they are not going to get paid on. So if they're sending you a case, I mean, I would still definitely do your homework with the facts of the case. But this is something where the case is going to pay out. There was clear liability, and the lawyer's not going to send you some. They're not going to do work on this if the accident or the case wasn't legitimate. I have had in the past our patients come in to the clinic, and a patient, they're entitled to any attorney that they would like to use, and they have chosen some attorneys before, and we had trouble getting paid on some of those because there wasn't clear liability. And I think sometimes the patients, they may choose a friend or someone that's close to their family that may not specialize in personal injury, and sometimes we have issues getting paid with that. But typically our referrals from our local personal injury attorneys, they're usually great cases, and the patient is really, they're hurt, and they can really benefit from chiropractic care.
One thing that I would add, that I just wanted before we moved on from this topic, is another thing that you should probably look at, especially those of you that are in more conservative areas, is you probably want to see a picture of the car, or the vehicles involved. If your client or if your patient, I'm sorry, it's hard as a lawyer to switch out of that, but if your patient comes in and says, I've been in a car accident, you should ask, like, can I see a picture of your car or pictures of the cars? Because I'm just going to be honest with you, especially around here in upstate South Carolina, if you got an accident where there's no visible damage or very little visible damage to the cars, that's going to be real hard to get any kind of value on, because everything a lawyer looks at and that an insurance company looks at is through the lens of what would a jury say about this? What would a jury believe caused your injuries? And oftentimes, and I've tried that case, and I'll be honest with you, I've lost that case. I've tried a case where you can't really see a whole lot of damage to the car. My lady was hurt, but juries just don't believe that sometimes. They're just like, well, I mean, there wasn't any damage to the car. How could she have been hurt? And no matter how much you talk about, prior issues that she had, she's, more susceptible to this than other people, sometimes they're just not having it. So I think it's important, also as a chiropractor, even though that's really sort of more the lawyer's role, since, your fortune is tied to, getting the case settled or getting some kind of resolution, you might want to take a look at those pictures and make sure we're not talking about a little, grocery store parking lot bump up or something like that.
I think that's great advice. So before we move on too, I'm curious, where do lawyers sort of see, so chiropractors, we're treating soft tissue cases. On your totem pole of injury cases, would you sort of give us chiropractors a reality check about the value of these cases? And are these are these, massive cases that bring in massive settlements? And also, would you also tell us, what is the general consensus of chiropractors in your field as attorneys? What do they think of chiropractors?
Sure. I'll start with your second question first. Attorneys in my field value chiropractors and what they do very much. And the reason for that is what y'all do is one of the few things that can be done for somebody with this type of injury. Like a lot of primary care doctors or doc in the box folks ER doctors even, they just basically are like, take some Flexeril, you'll be fine. And as you know from your patients, and as I know from talking to my clients, that's not how that works in reality. They need, somebody helping them get back to where they were before the accident by giving them treatment. It can take the form of PT, but frankly, chiropractic has really been beneficial for a lot of my clients who have been in these kind of car accidents. And what y'all do is immensely helpful to my clients and to your patients. But to your first question about where do these chiropractic cases fall on the spectrum of case value, I mean, very candidly, I mean, the bottom. I mean, these are sort of your bread and butter wreck cases that you see all the time. That doesn't mean that they don't hurt to go through them. That doesn't mean they don't cause you a great deal of pain or inconvenience. But as far as case value goes, I mean, that is sort of the lowest level of case there is. So if you're a chiropractor and you get a car wreck case, I guess to your point, you don't want to get too excited and be like, oh my gosh, like they're going to get all this money. Maybe in certain venues that's true. If you're a chiropractor in Chicago watching this, Cook County, Illinois, sure, yeah, maybe that's true. But around here and in most places throughout the country, that is not the case. They are typically, you're doing well to get the full medical bills plus, some extra money on top of that. That's really kind of what you're looking at. That sort of ratio varies based on, where the case is pending. But yeah, these are not cases you're going to retire on as a lawyer.
Yeah, I asked that question because I think it's good. Chiropractors, what we do is very valuable, but I think we need to have a reality check that sometimes our soft tissue cases, whether we like it or not, they're just in the big scheme of personal injury, they're just not worth that much. So we're going to talk about our billing and documentation. And so these are not, you can do well with personal injury cases, but you need to charge a reasonable amount. And this is why, like I said in the very beginning, I think it's great to have a practice that has different types of patients, cash paying patients, or, your maintenance patients that are cash paying, patients that are in active treatment that you're billing their health insurance, and then just a few personal injury cases, because there's a lot that goes into this, and it takes a lot of time. And I just don't think any wellness practice can really grow to the size that you want to be if over half your practice is personal injury. All right, so let's go ahead and move forward. So where do we start, Will? So we have a personal injury patient or a patient that's been in a car wreck, and they call your office and they want to make an appointment, and you've booked that appointment and it's their first day in the clinic. What things do we need to get and understand about this case, and what do we need to get from our patient?
Well, you need to get them, like in that first appointment, you need to get them to tell you how the accident happened. How are they feeling right then in that moment? Because so much of soft tissue cases and chiropractic injury cases are driven by what the client says, frankly. I mean, is what the client is reporting as their pain. And you need to track that. And y'all, I know I don't always get the terminology right, but I think the SOAP notes and things like that, over time you track, where you at 1 to 10 pain. With each visit being able to show in your records what they said. Now it's important to get that and get them to tell you how they're feeling. Obviously, clinically, y'all do what you do. But what I look for as the attorney is like that first, examination that you do, that first, physical exam you do, all the palpation and what spots are tender, where are they complaining of? Because I mean, frankly, if your client is complaining of lumbar pain, and then suddenly, a month and a half into your course of treatment, it's suddenly their thoracic spine hurts. You start to run into some issues there, causation wise. So it's important to track, exactly what body parts, what regions of the spine are bothering your patient. Another thing that you need to do from a business standpoint to protect yourself is to get an assignment or a lien. And what that is, in South Carolina, we don't really have formal, like, statutory provider liens like you do in, say, Georgia, or some other states around the country. But what you need to get is, you can call it a lien, an assignment, whatever it is. It needs to be a document executed by your client or signed by your client, that says, that they have a personal injury claim, and that they are assigning you in your office, rights to those settlement funds in the amount of whatever your treatment ends up being. Because if they don't do that, all yours is just a bill, and you're just like every other vendor or collections agency out there. And frankly, most of your clients are going to be judgment proof. In other words, like, even if you, and most of your patients, again, I'm sorry, they're not, you're not gonna be able to collect anything. So to make sure that you get paid back for your services, you need to have an assignment or a lien in place that says, I, John Doe, was in a car accident, and I assigned Simply Southern Chiropractic Center, the benefits of this settlement, to pay them back for any services that are incurred, and or something to that effect. You need to have something that says that they grant you rights into those settlement funds to be repaid, because otherwise, you just have a piece of paper that says I owe you, essentially.
So let's go back to some basics on this doctor's lien. So where do we get this? Do we write this? What information does it need to have in it?
Well, you could go to, another provider in town that has a good template. But what I would do is I would have one of your personal injury lawyers that you know and that you trust, that we are talking about earlier. Maybe not draft one for you, but if you have a template, have them look over it and make sure that it has the language in it that it needs to. Because if you don't do that and you just have something that isn't enforceable in any way, then it's just the same as having a bill. But the reason this is important, and the reason is another reason it's important to have a lawyer involved, is if you do have an assignment that the patient created, and the lawyer is on notice of it, then the lawyer's got to deal with that before he or she disperses any money. He can't ignore that. She can't ignore that. If he knows that there's an assignment from this, or in this settlement, from a chiropractor that the patient signed, you got to deal with that. Now, and we may get into this later about reductions and things of that nature. That doesn't mean that there's not conversations to be had about reductions or things like that. But they've got to deal with that interest that you have in the settlement before they disperse any money.
That's very important, and I recommend to all chiropractic offices, do not treat a patient without a doctor's lien. It needs to be signed. It needs to be sent to the lawyer that the patient is working with. We send it in multiple ways. We will mail it, fax it, and you can email it if you have a secure email. So make sure that they are on notice of that lien. I've learned from experience where my front desk, I know that the patient signed the lien and they did not send it to the lawyer. The case finished. We couldn't find the lien. And this was not a local lawyer. This was not someone that I knew and trusted. It was a lawyer in Georgia. We're in South Carolina. That case settled and finished, and they did not pay me. And so once you have that happen a couple of times, you'll realize that that sheet of paper is gold, and that is your payment. And so making sure that you have a lien and that you are not only do you have it, but you send it in before your case finishes. You're going to send your records after your case finishes, but you want to go ahead and send that lien. Will, you had a great recommendation to us that we have started doing, and this is another layer of protection for the chiropractor, because say that you don't have a great relationship yet with a personal injury attorney, you haven't worked with them much, you're just getting to know them, or I run into this when they're out of state. So what is something else that chiropractors can do to make sure that we get paid for the services that are rendered?
Another thing you can do is, once you have that doctor's lien or assignment signed by the patient, is send it to the liability carrier. Because they will have to deal with that too when they pay settlement funds to the claimant, or to the plaintiff, because they know about it. They know there's a claim against the money, and then they'll have to address it. before they can pay the injured person their money. So, you know, the reason it's crucial with the lawyer, especially though, is because lawyers have ethical obligations as part of the oath that they take whenever we're sworn into the bar, and they also have things called the rules of professional conduct that govern what we do. And in South Carolina, Rule 1.15 has to do with the safekeeping of property, and it also deals with claims against property by third parties. And in this case, that's y'all. Y'all are the third parties in this case. And if a third party can demonstrate a legitimate claim into property that's being held by an attorney, in this case, settlement funds, they have to deal with it. You have to address that issue. That doesn't necessarily mean you get paid that full amount, but the lawyer has to have some resolution of that issue before he disperses any money to himself or to his client.
So the patient, they're in the office, it's day one. I think what Will meant to say was the patient really needs to fill out OATs, so outcome assessment tools. That's really going to show progress in the patient as they go through treatment. Yes, we need SOAP notes, daily notes, both objective and subjective. Records about and from the patient, but the OATs, we want to fill those out on the first day, any sort of questionnaires that you have. So we've talked about the doctor's lien, but Will put this in order for us? So tell us from two different types of patients. Say we get a patient that calls our office and they come in for their first appointment and they tell us that they've been in a car wreck. What steps do we take? And then what about the patient that comes in, they already have an attorney, and what are the steps that we would take on that first day? And those are going to be different.
So the steps with somebody who has an attorney is, I guess, a little simpler. But you would take that doctor's lien or that assignment that you get from the patient, and you would immediately fax it, email it, mail it. Frankly, all three is probably fine, just so long as you can prove that that attorney was put on notice of your potential interest in the settlement funds. If you have a patient that comes in that does not have a lawyer, I think you need to, kind of like you were saying earlier, Dr. Duncan, you need to tell them, like, you need to hire an attorney. Who it is up to you. We have, Joe Blow, John Doe, and Jane Doe that we work with. You can talk to any of them. You're welcome to hire whoever you want. But, if we're going to handle a personal injury case for you, you need to have an attorney representing you to make sure that you're protected and obviously, so that you're also protected.
Yes. And so that's great advice. And so a way that we go about this in our clinic is, if a patient comes in and they already have an attorney, like Will said, this is very easy. You go ahead and have the patient sign the doctor's lien that day, and the patient does not pay for treatment starting on day one. If a patient comes into our clinic and they tell us they've been in a car wreck, we're going to figure out, this is South Carolina, were they at fault? And if they were not at fault, then we're going to tell them our office policy. Usually I let the patient go ahead. I'll do a case history. I want to get some facts of the case first and see if your patient, if they were in a parking lot and they got bumped and they just have a little bit of mid-back pain, sometimes it's not, these people after 3 or 4 appointments, they're going to meet MMI. So that's not, in my case, something where we would involve an attorney. But in a lot of cases, when patients come in, they've been in a, moderate to even severe car accident. They may not have broken any bones, but they've got a lot of soft tissue damage. And after I do a case history as the doctor, I will talk to the patient and say, in our office, we treat car accidents in 2 ways. Number one, you can pay for this yourself, and we will provide you with the records, and you can send this to the liability carrier to get reimbursed yourself. Or we can use an attorney and we can treat you for free in the office on a lien. It's not really for free, but they don't pay when they come in for their treatment up front. And this is the way that we prefer. And I tell them why. I say, we don't do the in-between. We're not going to treat you on a lien and then bill to the car insurance. We don't get paid. There's problems with that. The insurance company, we don't have time to deal with the insurance company. You can do that on your own time. And so what I say to the patient, we do make them pay for the first appointment, because at that point they haven't made a decision what they want to do. And we tell them, if you're going to use an attorney, we go ahead and set up their second appointment. By the time that you come into your second appointment, which is usually the next day or the following day, they need to have made contact with an attorney. They don't have to they don't have to have signed up yet, but they need to have made contact with that attorney. And so we do charge the patient how much it would cost for treatment until they have actually signed up with the attorney. And once they sign up with their attorney, then they can sign the doctor's lien. The patient does not need to sign a doctor's lien when they have not hired an attorney yet. And so I do think it's valuable to tell your patients, because they don't understand this at all, that with a personal injury case, they are not paying the attorney up front. This is not money out of their pocket. The attorney gets paid and we get paid when the case settles. And that is after treatment is rendered and after everything is worked out. Because I think a lot of times people are scared to use an attorney because they think it's going to cost money up front, and it's totally not. And actually, in reality, the patient's going to get, not that money is the main driver here, but the patient's going to get more compensation by using an attorney, because they're going to probably get a majority of their medical treatment paid for, and they may get something for pain and suffering, which I don't get into this with patients. That's not my place. I'm not an attorney, but in reality, the patient's going to be so much better off if they have somebody that's on their side and that's representing them with these insurance companies. And so that's sort of how we handle it in our clinic. And then most of our patients, they will actually end up using an attorney. They can use any attorney that they want to. We recommend, we have a couple that we love working with. And so we'll say, this is who we usually work with. We trust them and we enjoy working with them, but you can use any attorney that you would like. And so by that second appointment, you need to have a decision by your patient. And also, my suggestion is you need to still charge the patient until they sign up with an attorney. And then once they do, you can refund that right back to them. So, okay, let's talk about the patient was in a car wreck. When should we start treating them? Should we treat them same day? Should we wait a couple weeks? What does that look like, Will?
Well, you need to get them in as soon as possible. And hopefully, even before they've come to you, they've at least gone to the emergency room or at least a doc in the box or something. I understand, I'm married to a chiropractor. I understand that, like, a lot of times those providers don't always do the best job treating car accident victims with these type of injuries. I understand that. But from the insurance company's evaluation standpoint, and frankly, from a jury standpoint, it doesn't look good if somebody's been in a car accident and then they're going to say, I've been in pain for 2 months, 3 months, 4 months, and then they didn't even go to the emergency room or to urgent care right after the accident. That's just not a good look, especially, as I said, in your more conservative venues. But all is not lost if they haven't done that. But they need to get into your office ASAP after that accident. If you get somebody that comes to your office and says, I was in an accident a month ago, and they haven't had any medical treatment of any kind, you do not want to get involved in that. Obviously, treat them, help them with their injuries, but you don't want to be, treating them in a lien or letter of protection type scenario. You don't really want to get into that, because there's a good chance that patient loses that case if they try it, or the settlement that they get is the medical bills only or something like that.
Yeah, I think it's important for chiropractors to hear this. A lot of our patients, they choose, especially people that know about chiropractic care, they are choosing alternative care because they don't want to see a medical provider, or they don't want to take medication, which is fine. That's the majority probably of a lot of our patients in our clinics. But I didn't know this as a chiropractor until I learned this from Will. the value of the case goes up significantly if the patient goes to a medical doctor, and it'd be great if they went to a medical doctor even before they came to the chiropractor. And yes, what's a medical doctor in a soft tissue injury going to do? Probably prescribe muscle relaxers. They may prescribe some steroids. We know as chiropractors that's not going to fix the root problem, but I will say, if you have a really acute patient, those things can help bring down inflammation, which I sometimes think are very helpful. But I did not realize the importance of our patients. They really do need to touch base with their medical provider before they come into the chiropractic office. Do you have anything else to say about that, Will?
No, I just think it's really important that that the patient has already done that. And when I say that, obviously, if they don't feel like they need anything like that, then don't go. But if you don't feel like you need anything like that, you probably don't need to pursue a personal injury claim. I mean, that's just kind of the long and short of it. And that's the way that a jury is going to look at it. And I can guarantee you that's the way an insurance adjuster is going to look at it.
Well, I'm going to speak on behalf of some of our patients here. They may just not trust the medical community at all. And so I don't totally agree with that statement saying that they might not need treatment if they, don't need to go to the medical doctor. But I think it's important as chiropractors to have this conversation with our patients and say, listen, as your trusted chiropractor, you trust me in the natural medicine world. I am suggesting that you go to your medical doctor. Let's make sure that we get a complete evaluation on our side and theirs. But because we're going to have patients that are stubborn and they just don't want to go, and they never want to step foot in a hospital, and they never want to take any sort of prescription medication. And so their case sometimes it still can be valuable, and they can be hurt. I've seen people I've got, we all have this. I've had a patient that was in a wreck and they had a compression fracture in their spine, and I knew they were hurting. We just saw that on our x-ray film, but they just would not go to a medical doctor. And so that's a conversation I think that's important for our patients.
Yeah, and I just want to make clear, I'm not saying that I don't think they should ever just go to chiropractic. That's fine. What I was getting at was if there's been some time that's gone by and they're still sitting there thinking like, I don't need to go to the doctor. No, if somebody comes into your clinic the day of the accident or next day or 2 days later, and they just, for whatever reason, like you said, don't want to go to the hospital or don't want to go to a medical doctor, I mean, that's fine. There's nothing wrong with that. And in fact, that may be, frankly, in many ways, the more effective way from a pain management standpoint and, addressing the root cause, as you said. But, I'm speaking from, a lawyer and how I handle these cases and, frankly, the way that a jury or insurance adjuster would probably view it.
Sure. You've definitely changed my perspective on this. And, we want to, too, this is a business too for chiropractors. We want to get paid on these cases. And whether we like it or not, if our patient sees a medical provider, the value of the case is going to go up. And so that will help us get paid too. So, all right. So when we talk about, you mentioned that the patient should come in right after the accident. Does this mean same day, or like what is the time frame there?
All I can say is the sooner the better. Same day would be great. Next day would be fine. 2 days would be okay. It's just a general rule of thumb. If you're getting to be, a week, 2 weeks out, and you hadn't had any treatment since the accident, that's when you're starting to get real iffy on whether or not this is something you should get involved in from a personal injury claim standpoint. Doesn't mean that they don't need treatment or whatever. But that's somebody that you want to make sure is paying cash, rather than hoping that you get repaid by a car insurance company.
A tactic sometimes that we'll use to try to help get the patient in is, I know you say you have a busy clinic. We have a very busy clinic, and sometimes we can't same day when we get a phone call, we can't get the patient in. But what we will do is we will schedule them a little bit of time to come in and at least start their paperwork. And so the paperwork can take a while. It can take, 30 minutes to an hour. And so the next day we can go ahead and start the exam. And so then we can get if we have a busy clinic, we can get the patient in the next day and they're not having to spend all that time doing paperwork, and we can get straight to the exam and sort of fit them in. So that's a way that we've learned in our clinic where it is busy to go ahead and it gets the patient in the door, it gets them established, they've completed the paperwork, you've already had the conversation about, are you going to pay for this out of pocket or are you going to use an attorney? And so then the next day you can start rocking and rolling. That's sort of a tactic that we use. So Will, what if we get a call from an attorney and they want to send us a personal injury patient, and that patient was in a wreck a month ago, 4 months ago, 6 months ago? That'll happen sometimes. Why does that happen, and should we take that patient?
Well, that's a good question. And what I would say is you're going to need some information about what kind of treatment that patient has had up to that point. If they went to the emergency room, if they went to urgent care, if they've been following up with their primary care doctor or with some other physician, I think you could think about taking that case on. If their physician says that they need some sort of conservative therapy to deal with their muscle sprain or strain, then I think that you could do that. I think that you would be fine to do that. Now, it's whenever you have huge, and I would think most personal injury lawyers with any sense would know not to try to create new treatment 6 months after the fact. I mean, talking about attorney-directed treatment is already problematic for other reasons. The more your patient leads things and that you as the provider lead things, the better. Because when attorneys start referring people to providers, the insurance company loves that. They love you saying, "Oh, your attorney's doing this to jack up the bills and make this a bigger case." And now, look, that attack is kind of unfair. It is very unfair in some cases, because one of the things that y'all really do for people is for folks who don't have any kind of health insurance or anything like that. Sometimes the chiropractor is the only way they're going to get any treatment. And an attorney oftentimes is the only person who knows the kind of chiropractors who they can trust, right? That goes both ways. Trust is a two-way street. Y'all have got to find attorneys you can trust, but attorneys got to find chiropractors you can trust. They got to find people who will have a nice, clean, well-appointed office with professional people who care. All of those things are important. You don't want to just send your client to somebody who's going to run up some astronomical bill in a dingy strip mall somewhere. I mean, you don't want to do that to your clients. So you want to make sure that there's been treatment up to that point, and you want to make sure there hasn't been any huge treatment gaps before you agree to treat someone on a lien or a letter of protection.
That's great information, and that's great advice. And I think this is why it's so important to have a personal relationship with local attorneys and get to know them. And that's why it's just so important to work with people that you've got some history with and you trust. And so we definitely have that, and it's taken years to get that. You learn who's good to work with and who's harder to work with. But if you have an attorney that you trust, I don't think they're going to send you a case that is not worth your while. And so that's why it's really important if a patient is referred to you, and a lot of time has gone by since the accident, just you can have that trust there with that legal counsel.
Well, thank you so much, Dr. Duncan and Will, just giving us all a rundown of so many important things that I'm sure will benefit so many people, especially clinic owners and their clinics, to make them run successfully and smoothly, especially in such a gray area. So again, if you took anything away from this podcast today, Dr. Duncan offers coaching on her website, drmaryfrancisduncan.com. This is a place where you can meet one-on-one with Dr. Duncan and go through kind of the nitty-gritty of all of this that we talked about today. This is just the tip of the iceberg. I am sure before. So there is so much that we could really dive into with Dr. Duncan. So if you took anything away from that, you can always check out her website, Dr. Duncan, drmaryfrancisduncan.com. And additionally, like I said at the very beginning, if you took anything away from this podcast, please leave us a 5-star review and let us know your thoughts and what you want next. We love to hear what you guys want to hear, and making sure that we're keeping I'm Simply Saying entirely up to the audience. So thank you again so much, Will, for joining us. And additionally, thank you for watching and tuning in to I'm Simply Saying.
Ding-a-ling,